Hello, everyone, and welcome to Uncivil Law, where we learn through the misfortunes of others. As always, I hope you'll enjoy this legal education content, and today will be the day I earned that subscription. For today's story, we are talking about the city of Austin versus Reagan National Advertising. This is a case dealing with billboards and what can be on those billboards and where those billboards can be. Okay, so here's what happened. The city of Austin passed a regulation dealing with billboards. And they said that for on-premise billboards, they could be electronic. For off-premise billboards, not so much. They couldn't be electronic. They had to be the old traditional kind of billboard. So there was a question on this issue, and the Fifth Circuit Court of Appeals said that, you couldn't determine what was on-premise or off-premise without reading the sign. I thought this was a pretty good argument. Okay, so you're at a bank, right? You're at a bank, and the bank has a digital billboard, as many banks do. I'm sure you've seen them. Typically, they will display things like the time and temperature and some information about the bank. Like apply for this new credit card, or apply for a new savings account today, free toaster, whatever, right? That would be the kind of thing you would expect to see. So is that an on-premise sign or an off-premise sign? Well, given the description, you might say it's an on-premise sign. But what if someone pays the bank to put things other than banking information on the sign, right? They reach a deal with someone else, like, the car chain, the mechanic shop down the street, right? The mechanic shop down the street is a customer of theirs, and they reach an advertising deal. The mechanic shop says, hey, why don't you put on that sign, check out, Bob's Mechanic Shop for really good repairs on your car. Okay, so now is it an on-premise sign or is it an off-premise sign? Because the nature of on-premise versus off-premise changes with the messaging. If it's talking about the bank, it's on-premises. But the moment you talk about the shop down the street, it's off-premises. So therefore, to determine whether it's on-premise or off-premise, you have to read the sign. Also implicitly means that you can't put certain things on the sign, because then they would be off-premise, which isn't permitted. So the Fifth Circuit Court of Appeals said, look, we can't determine what's on-premise or off-premise without reading the sign. And once we read the sign, it's now a content-based regulation, because we are regulating based on the content. So the apparently neutral rule that says on the apparently neutral rule, time, place, manner neutral, at least content neutral. The content neutral rule that said on-premise signs, digital, off-premise signs, not digital, although it apparently is it's content neutral, in reality, it's content-based. This was the decision of the Fifth Circuit. I thought this decision made a lot of sense. Well, the United States Supreme Court has reversed that decision and said, no, it actually is not a content-based regulation. Even though you have to read the sign, to some degree, it is not a content-based regulation. What's also really interesting about it, from my point of view, is the split on the court. It was 6-3, and the people in the majority are what you might consider to be the most left-leaning members of the court. So in addition to the normal, usual suspects of the left-leaning court, you also got Roberts and Kavanaugh, who is probably the most left-leaning of the remaining justices when you sort of do the math in your head. Or at least he's the one most likely to agree with this. So it's interesting because, I thought it goes one way and the left thought it went one way, but the right-leaning part of the court disagreed with me. So interesting to see on the judicial philosophies about why this is. So can they convince me? Can the majority convince me that I was wrong and this really is a content-neutral regulation? I'm up for that. I'm up to be convinced wrong, so let's see what we got. All right. Here's the decision. Why am I sweating? I'm not sweating in particular, but thank you for asking. Justice Sotomayor delivers the opinion of the court. Like thousands of jurisdictions around the country, the city of Austin, Texas, regulates signs that advertise things that are not located on the same premises as the sign, as well as things that direct people to off-site locations. These are known as off-premise signs and include, most notably, billboards. The question presented is whether, under the court's precedent interpreting the free speech clause of the First Amendment, The city regulation is subject to strict scrutiny. We hold it is not. So this comes down to the question of whether or not this is a content-based regulation or content-neutral regulation. Okay. American jurisdictions have regulated outdoor advertisements for well over a century. By some accounts, the proliferation of conspicuous patent medicine advertisements on rocks and barns prompted states to begin regulating outdoor advertising as late as the 1860s. As part of this regulatory tradition, federal, state, and local governments have long distinguished between signs, such as billboards, that promote ideas, products, or services located elsewhere, and those that promote or identify things located on site. For example, this court in 1932 reviewed and approved of a Utah statute that prohibits signs advertising cigarettes and related products, but allowed businesses selling such products to post on-sign signs identifying themselves as dealers. Okay. Off-premise distinctions, like the one issue here, proliferated following the enactment of the Highway Beautification Act of 1965. In the act, the Congress directed states receiving federal highway funds to regulate outdoor signs in proximity to federal highways, in part by limiting off-premise signs. Under the act, approximately 2/3 of states have implemented a similar off-premise, on-premise distinction. The city represents and respondents have not disputed that tens of thousands of municipalities nationwide have adopted analogous on-premise distinctions in their sign code. Analogous, yes, but how they're written is, obviously going to be very questionable. The city of Austin is one such municipality. The city distinguishes between on-premise and off-premise signs in its sign code, and specially regulates the latter in order to protect the aesthetic value of the city and to protect the public safety. Okay? During the time period relevant to this dispute, the city's sign code defined the term off-premise sign to mean a sign advertising a business, person, activity, good, product, or service not located on the site where the sign is installed or directs the person to any location not at that site. A reasonable definition. This definition was materially analogous to one used in the Federal Highway Beautification Act and many other state and local codes referenced above. The code prohibited the construction of any new off-premise sign, but allowed existing off-premise signs to remain grandfathered as non-conforming signs. So no new off-premise signs. Okay, no new billboards. Fine. An owner of a grandfathered off-premise sign could continue to maintain it at its existing location and could change the face of the sign, but could not increase the degree of existing nonconformity. That is, by changing the method of technology to convey a message or increasing the illumination of the sign. So you allow the sign as it was initially permitted, and although new signs are permitted, you can maintain the sign as originally permitted. You cannot change the nature of the sign, though, but you can change what's on the sign. Makes logical sense. By contrast, the code permitted the digitization of on-premise signs. Fine. Respondents, Reagan National Advertising of Austin and Lamar Advantage Outdoor Company, are outdoor advertising companies that own billboards in Austin. In April and June of 2017, Reagan sought permits from the city to digitize some of its off-premise billboards. The city denied the application. Reagan filed suit against the city in the state court alleging the code's prohibition against digitizing off-premise signs, but not on-premise signs, violated the free speech clause of the First Amendment. The city removed the case to federal court and intervened as plaintiff. Okay, fair enough. After the parties stipulated to the pertinent facts, the district court held a bench trial and entered judgment in favor of the city. As relevant, the court held the challenged sign code provisions were content neutral under the case of Reed versus Town of Gilbert. The court concluded the on-off-premise distinction did not impose greater restrictions for political messages, religious message, or any other subject matter, and did not require a viewer to evaluate the topic, idea, or viewpoint of the sign. Instead, it required the viewer only to determine whether the subject matter is located on the same property as the sign. The court therefore held that the distinction was facially content-neutral regulation based on location, The court further found no evidence in the record the city had applied the sign code provisions differently for different messages or speakers. Fair enough as to that. Or that its stated concern for aesthetics and safety was a pretext for any other purpose. Also fair enough. Accordingly, the court reviewed the city's on-off-premise distinction under the standards of intermediate scrutiny applicable to content-neutral regulation of speech. That would be the correct standard for content-neutral speech. Intermediate scrutiny. Fine. The court found the distinction satisfied the standard. Also, well, at least debatable, but a reasonable conclusion. The Court of Appeals reversed. The court opined that because the city's on-off-premise distinction required a reader to inquire as to who the speaker is and what the speaker is saying, both hallmarks of a content-based inquiry, the distinction was in fact content-based. It reasoned the fact that the government official has to read the sign to determine the sign's premise is enough to render a regulation-based, content-based, and subject it to strict scrutiny. The court acknowledged its interpretation of read was broad, but reasoned that the consequences were not unforeseen, given concerns raised by justices who did not join the opinion of that court. Because the Court of Appeals determined the city's on-off-premise distinction imposed a content-based restriction on speech, it reviewed that distinction under the onerous standard of strict scrutiny. Recognizing that strict scrutiny is understandably a hard standard to meet, which, basically borderline impossible, and that it leads to almost certain legal condemnation, the court held the city's justification for distinction could not meet the standard, rendering it unconstitutional. The court therefore grants certiorari. So this is exactly the question. Is it a content-based or content-neutral sign? Or regulation, I should say. So is it content-based or content-neutral? It's on its face, content-neutral. But then again, to determine what it is, you actually have to read the sign, which seems like you're regulating based on content. But maybe not. Convince me. A regulation of speech is facially content-based under the First Amendment if it targets speech based on its communicative content. That is, if it applies to particular speech because of the topic discussed or the idea of the message expressed. The Court of Appeals interpreted read to mean that if a reader must ask, who is the speaker and what is the speaker saying, to apply the regulation, the regulation is automatically content-based. This rule, which holds that a regulation cannot be content-neutral if it requires reading the sign at issue, is too an extreme interpretation of this court's precedent. All right? Unlike regulations issued in read, the city's off-premise distinction requires an examination of speech only in service of drawing a neutral location-based line. It is agnostic as to its content. Okay. So the idea here is that it is only tangentially related to the speech instead of about the speech itself. Is that the idea we're going with? That it's not, although it involves reading the content, it's only in a tangential sense. So therefore, it's still a content neutral regulation. All right, we can give that a shot. Thus, absent a content purpose or justification, the city's distinction is content neutral and does not warrant the application of strict scrutiny. The prior case, the Reed Court, confronted a very different regulatory scheme than the one at issue here. A comprehensive sign code that singled out specific subject matter for differential treatment. The town of Gilbert, Arizona had adopted a code that applied distinct size, placement, and time restrictions to 23 categories of signs. That is a lot of different categories. The court focused its analysis on 3 categories defined by whether the signs displayed ideological, political, or certain temporary directional messages. The code gave most favorable treatment to ideological signs, defined as those communicating a message or ideas for non-commercial purposes with certain exemptions. It offered less favorable treatment to political signs, defined as those designed to influence the outcome of an election. Most restricted of all were temporary directional signs relating to qualifying event, with qualifying events defined as gatherings sponsored or arranged or promoted by religious, charitable, community service, educational, or other similar nonprofit organizations. The Reed Court determined that these restrictions were facially content-based, rejecting the contention that the restrictions were content-neutral because they did not discriminate on the basis of viewpoint, and viewpoint-based discrimination is a little different than content-based regulation, so, all right. The court explained it's well established that the First Amendment hostility to content-based regulation extends not only to restrictions on particular viewpoints, but also on prohibition of public discussions of entire topics. That would be a hallmark of content-based regulation, right? Viewpoint-based regulation is you can't express certain views. Content-based regulation is you can't talk about certain subjects at all. Applying these principles, the court reasoned that a speech regulation targeted at specific subject matter is content-based even if it does not discriminate among viewpoints within the subject matter. For example, a law banning the use of sound trucks for political speech, and only political speech, would be content-based regulation, even if it imposed no limits on political viewpoints that could be expressed. All right, fair enough. By treating ideological messages more favorably than political messages, which I'd also like to point out are somewhat ideological, and more favorably than temporary directional messages, the town's sign code likewise singled out specific subject matter for direct differential treatment, even if it did not target viewpoints within that subject matter. Okay. In this case, enforcing the city's challenge sign code provisions requires reading a billboard to determine whether it directs readers to the property on which it stands or to some other off-site location. Unlike the sign code at issue in Reed, however, the city's provisions at issue here do not single out any topic or subject matter for differential treatment. I don't know about that, but okay. A sign's substantive message itself is relevant to the application of these provisions. There are no content discriminatory classifications for political messages, ideological message, or directional messages concerning specific events, including those sponsored by religious and nonprofit organizations. $5 from Hell Pike. You are my favorite on the panel in the stream today. Thank you for not talking over JD, the judge, and defense attorney. Well, I just didn't have anything particular to say at those moments, but you are welcome. Rather, the city's provisions distinguish based on location. A given sign is treated differently, based solely on whether it is located on the same premises as the thing being discussed or not. The message on the sign matters only to the extent it informs the sign's relative location. Okay. The off-premise, on-premise distinction is therefore similar to ordinary time, place, or manner restrictions. Reed does not require application of strict scrutiny to this kind of location-based regulation. So, we do have to read the content of the sign, but only to determine the location of the sign. So it's still a content-neutral regulation. The court's First Amendment precedents and doctrines have consistently recognized that restrictions on speech may require some evaluation of speech and nonetheless remain content neutral. Most relevant here, the First Amendment allows for regulations of solicitation. That is, speech requesting or seeking to obtain something or to attempt to effort to gain business. To identify whether speech entails solicitation, one must read or hear it first. Even so, the court has reasoned that restrictions on solicitation are not content-based and do not inherently present the potential for becoming a means of suppressing a particular point of view, so long as they do not discriminate based on topic, subject matter, or viewpoint. Well, I don't know whether or not I agree with this logic or not, so I'm going to have to think this through for a second. All right, so a solicitation at its core is business speech. And business speech is sometimes treated differently than regular kinds of speech. Commercial speech is sometimes treated differently than other forms of speech. Okay, so this is a solicitation. This is a buy something, presumably, solicitation. All right, So that's commercial in its nature. Okay. We can regulate the solicitation speech. Okay. In order to determine whether or not it's solicitation speech, we have to know its content. True. So it doesn't become content-based. We merely have to determine whether it's commercial or not, or solicitive or not. But we are not prohibiting discussion of a topic. Well, I guess we kind of are. We're prohibiting discussion of soliciting messages, but maybe it's broader than that. Maybe the category is broader. So even though we are prohibiting discussion of particular topics, the particular topics are broad. And so it's not a problem under the First Amendment analysis. Okay. I'm going to let that sit for a second as I think about it. Thus, in 1940, the court invalidated a statute prohibiting solicitation for religious causes, but observed that states were free to regulate the time and manner of solicitation generally in the interest of public safety, peace, comfort, or convenience. Decades later, the court reviewed such a time, place, and manner restriction, restricting all solicitors at the Minnesota State Fair, as well as all sale to distribution of merchandise. Why is my camera occasionally just freezing? I don't know why that's doing that, and it's very frustrating. Something somewhere is doing something. I'll have to look at the... let's try to figure out what's causing that. Decades later, the court reviewed such a time, place, manner restriction restricting all solicitation at the Minnesota State Fair, as well as all sale or distribution of merchandise to a specific location. The state had applied the restriction against the religious practice it included, soliciting donations for the support of the Krishna religion. As a result, members of the religion were free to roam the fairgrounds and discuss their beliefs, but they're prohibited from asking for donations for their cause outside of a designated location. The court upheld the state's application of this restriction as content neutral, emphasizing it applied even-handedly to all who wish to solicit funds, whether for commercial or charitable reasons. Okay. Consistent with these precedents, the court has previously understood distinctions between on-premise and off-premise signs, like the one at issue in this case, to be content neutral. In 1978, the court summarily dismissed an appeal for one of substantial federal question, where a state court had approved an on-premise, off-premise distinction as permissible time, place, and manner restriction under a free speech clause. 3 years later, the court upheld in relevant part an ordinance that prohibited all off-premise commercial advertisement, but allowed on-premise commercial advertisement. Okay. The court did not need to decide whether the off-premise prohibition was content-based, as it regulated only commercial speech, and was subject to intermediate scrutiny in any event. That is the typical rule. Shortly, however, the court applied the relevant portion of the case and described the off-premise prohibition as a content-neutral prohibition against the use of billboards. Underlying these cases and others is a rejection of the view that any examination of speech or expression inherently triggers the heightened First Amendment concern. Rather, it's regulations that discriminate based on the topic discussed or the idea or message expressed that are content-based. Okay. The sign code provisions challenged here do not discriminate on those bases. All right. Reagan does not claim Reed expressly or implicitly overturned precedents discussed above. Its argument relies primarily on one sentence in Reed, recognizing that some facial distinctions based on message are obvious, defining regulated speech by a particular subject matter, and others are more subtle, defining regulated speech by its function or purpose. Seizing on this reference, Reagan asserts the sign code defines off-premise signs based on their function or purpose, and then asks the courts to reaffirm that where regulation defines regulated speech by its function or purpose, it is content based on the face and thus subject to strict scrutiny. Okay. The argument stretches Reed's function or purpose language too far. The principle the Reed court articulated is more straightforward. While overt subject matter discrimination is facially content-based, for example, ideological signs, defining those as communicating a message or ideas for a non-commercial purpose, so too are subtler forms of discrimination that achieve identical results based on function or purpose. For example, political signs defined as those designed to influence the outcome of an election. In other words, a regulation on speech cannot escape classification as facially content-based simply by swapping out an obvious subject matter distinction for a function or purpose proxy that achieves the same result. Okay. That does not mean any classification that considers function or purpose is always content-based. Such a reading of function or purpose would contravene numerous precedents, including many of those discussed above. Reed did not purport to cast doubt on all those cases. Okay. Nor did Reed cast doubt on the nation's history of regulating off-premise signs. Off-premise billboards of the sort that predominate today were not present in the founding era, but as large outdoor advertisements proliferated in the 1800s, regulation followed. As early as 1932, the court had already proved a location-based differential for advertising signs. Thereafter, for the last 50 years, the federal, state, and local jurisdictions have repeatedly relied upon on-premise distinction to address this distinct safety and aesthetic challenges posed by billboards and other methods of outdoor advertising. The unbroken tradition of on-off-premise distinctions counsels against the adoption of Reagan's novel rule. All right. Tellingly, even today's dissent appears reluctant to embrace the read the sign rule adopted by the court below. Instead, the dissent attacks a straw man. Okay. Contrary to its accusations, we do not nullify Reed's protections, resuscitate a decision that we do not cite, or fashion a novel specific test simply by quoting the standard repeatedly enunciated in Reed. Nor do we cast doubt on any of our precedents recognizing examples of topic or subject matter discrimination as content-based. We merely apply those precedents to reach the common sense result that location and content agnostic on-off-premise distinctions does not, on its face, single out specific subject matter for differential treatment. It is the dissent that would upend settled understandings of law. Where we adhere to teachings of history, experience, and precedent, the dissent would hold tens of thousands of jurisdictions have presumptively violated the First Amendment, some for more than half a century, and they've done so by use of an on-off-premise distinction this court has repeatedly reviewed and never previously questioned. For these reasons we have explained, this Constitution does not require this bizarre result. All right. This court's determination that the city's ordinance is facially content neutral does not end the First Amendment inquiry. If there's evidence that an impermissible purpose or justification underpins a facially content neutral restriction, for instance, that restriction may be content-based. Moreover, pausing of video. Let me see if I can fix this issue real fast because it's driving me crazy. Let me change the priority and see if that helps. Just change it to high priority. See if that helps. Okay. The court's determination that the city ordinance is facially content neutral does not end the First Amendment inquiry. If there's evidence that an impermissible purpose or justification underpins a facially content neutral restriction, for instance, that restriction may be content-based. Moreover, to survive intermediate scrutiny, a restriction on speech or expression must be narrowly tailored to serve a significant governmental interest. The parties dispute whether the city can satisfy these requirements. The court, however, is a court of final review and not first view, and does not ordinarily decide in the first instance issues not decided below. In particular, when we reverse on a threshold question, we typically remand for resolution of any claims the lower court's error prevented them from addressing. Because the Court of Appeals did not address these issues, the court leaves them for remand and expresses no view on this matter. For these reasons, the judgment of the Court of Appeals for Fifth Circuit is reversed, and the case is remanded for further proceedings consistent with this opinion. Well, I think that's a pretty good argument. It makes logical sense. It is trying to toe a line that is a little bit arbitrary, but, what else is new in law? So we are saying it's not a content-based regulation because we are not trying to discriminate based on subject matter. We're not trying to say certain subjects are okay or not. We're only trying to say that certain locations are okay or not. And so we have to read the sign for that purpose, which incidentally means that digital billboards can't present certain content. I mean, implicitly, which is where I run into a bit of a problem. Right. So, all right. Let's read some dissent and see if it makes more sense than the majority's decision. Because I'm like, okay, this could work. But let's see if the dissent is stronger. I agree with the majority that we must reverse the decision of the Court of Appeals, holding the provisions. Oh, this is concurring in part and dissenting in part, so we don't need to read that. We'll just read the straight up dissent. Justice Thomas, along with Gorsuch and Barrett. All right, let's take a look at this. In Reed versus Town of Gilbert, we held that a speech regulation is content-based and thus presumptively invalid if it draws distinctions based on the message the speaker conveys. Here, the city of Austin imposes special restrictions on off-premise signs, defined as signs that advertise a business, person, activity, good, products, or service not located on the site where the sign is installed or directs that person at any location not on the site. Under Reed, Austin off-premises restrictions are content-based. It discriminates against certain signs based on the message they convey, whether they promote an on- or off-site event, activity, or service. The court nevertheless holds that the off-premise restriction is content-neutral because it prescribes a sufficiently broad category of communicative content and therefore does not target a specific topic or matter. That does seem to be like where the majority was going, and I said as much during that analysis. This misinterprets Reed's clear rule for content-based restrictions and replaces it with an incoherent and malleable standard. In doing so, the majority reasoning is reminiscent of this court's erroneous decision in Hill versus Colorado, which upheld a blatantly content-based prohibition on counseling near abortion clinics on the ground that discriminated against extremely broad category of communications. Okay. In Reed, we held that courts should identify content-based restrictions by applying a common sense test. A speech regulation is content-based if it targets speech based on its communicative content. Put another way, a law is content-based on its face if it draws distinctions based on the message a speaker conveys. While we noted that some facial distinctions based on message are obvious, we emphasized that others could be more subtle, defining regulated speech by its function or purpose. In all events, whether a law is characterized as targeting topic, idea, subject matter, or communicative content, that law is content-based if it draws distinctions based any way on the message the speaker conveys. Okay. Applying the standard, we held the Town of Gilbert sign code was a paradigmic example of content-based discrimination because it classified various categories of signs based on the type of information they conveyed, and then subjected each category to different restrictions. For instance, Gilbert defined temporary directional signs as any sign that conveyed the message of directing the public to a qualifying event and permitted their display for no more than 12 hours before the event occurred. $9.99 from Stephen Light. Thanks as always for your great content. Stephen, you are most welcome, and thank you for the super chat. Meanwhile, ideological signs defined as any sign not covered by another category that communicated a message or ideas for non-commercial purposes were subject to no temporal restrictions. In short, the restrictions for any given sign depended on the communicative content of the sign. Okay. Gilbert's sign code was thus facially content-based and presumptively unlawful. In contrast to Reed's common sense test, Gilbert urged us to define content-based as a term of art that should be applied flexibly with the goal of protecting viewpoints and ideas from government censorship or favoritism. Such a functionalist test, Gilbert argued, could ferret out illicit government motives while obviating the need to subject reasonable laws to strict scrutiny. We rejected Gilbert's attempt to cast the phrase content-based as a term of art because innocent motives do not eliminate the danger of censorship presented by a facially content-based statute. We note that one could easily imagine a sign code compliance manager who disliked a church's substantive teachings, deploying the sign code to make it more difficult for the church to inform the public of the location of its services. Thus, we concluded that a clear and firm rule governing contract neutrality is the essential means of protecting the freedom of speech, even if laws that might seem entirely reasonable will sometimes be struck down because of their content-based nature. We also rejected the Ninth Circuit reasoning that Gilbert's sign restrictions were content neutral because they depend on the content neutral elements of whether and when an event is occurring. That is, whether a temporary directional sign was permissible depended in part on its temporal proximity to a qualifying event. The partial dependence on content neutral elements was immaterial, we explained, because the restrictions also depended on the sign's communicative content. Gilbert officials still had to examine a sign's message to determine what type of sign it was, and this obvious content-based inquiry did not evade strict scrutiny simply because an event was involved. Under Reed's approach for identifying content-based regulations, Austin's off-premise sign restriction is content-based. As relevant to this suit, Austin's sign code imposes stringent restrictions on a category of off-premise signs. The code defines off-premise signs as those that advertise a business, person, activity, goods, products, or services not located on the site where the sign is installed, or signs directing persons to any location not on that site. This broad definition sweeps in a wide swath of signs, from 14 by 48 billboards to 24 by 18-inch yard signs. The sign code prohibits new off-premise signs and makes it difficult or impossible to change existing off-premise signs by including digitizing them. True enough. Like the town in Gilbert and Reed, Austin has identified a category of signs based on the type of information they convey, and then subjected the category to different restrictions. A sign that conveys a message about off-premise activities is restricted, while one that conveys a message about on-premise activities is not. And per Reed, it does not matter that the Austin Code defines regulatory speech by its function or purpose, that is, advertising or directing passing by elsewhere. Again, all that matters is the regulation draws distinctions based on a sign's communicative content, which the off-premise restriction plainly does. This conclusion is not undermined because the off-premise sign restriction depends in part upon a content-neutral element, the location of the sign. Much like in Reed, that an Austin official applying the sign code must know where the sign is does not negate the fact he also must know what the sign says. Take, for instance, a sign outside a Catholic bookstore. If the sign says, "Visit the Holy Land," it is likely an off-premise sign because it conveys a message directing people elsewhere, unless the name of the bookstore is Holy Land Books. But if the sign instead says, "Buy more books," it is likely permissible on-premise sign unless the sign also contains an address of another bookstore across town. Finally, suppose the sign says, "Go to confession." After examining the sign's message, an official will need to inquire whether a priest ever hears confessions at that location. If it does, the sign could convey a permissible on-premise message. If it does not, the sign conveys an impermissible off-premise message. Because enforcing the sign code in any of these instances requires officials to determine whether a sign conveys a particular message, the sign code is content-based under Reed. Okay, that kind of makes sense to me too, to be honest. I'm thinking. Okay. To reach an opposite result, the majority implicitly rewrites Reed's bright line rule for content-based restrictions. In the majority's view, the off-premise restriction is not content-based because it does not target a specific topic or subject matter. Okay. The upshot of the majority's reasoning appears to be a regulation based on sufficiently general or broad category of communicative content is not actually content-based. That does seem to be where the majority is going, yes. Such a rule not only conflicts with Reed and many Reed precedents, but is also incoherent and unworkable. Tellingly, the only decision that even remotely supports the majority's rule is one it does not cite. Hill versus Colorado. There, the court held that an undeniably content-based law was nonetheless content-neutral because it discriminated against an extremely broad category of communications, supposedly without regard to subject matter. The majority's decision today is erroneous for the same reasons Hill is an aberration of our case law. The majority concedes that the message on the sign matters when applying the sign code. That concession should end the inquiry under Reed. But the majority nonetheless finds the sign code to be content neutral by recasting facially content-based restrictions as only those that target sufficiently specific categories of communication and not those that depend on the communication content simpliciter. For example, while Reed defines content-based restrictions as those that draw distinctions based on the message a speaker conveys, the majority decides the Austin sign code is not content-based because it draws no distinctions based on a sign's substantive message. Elsewhere, the majority speaks not of substantive message, but of topics or subject matters, which the majority thinks are sufficiently specific categories of communicative content. As a result, the majority contends that a law targeting directional messages concerning events generally, regardless of topic, would not be content-based, but one targeting directional messages concerning specific events would be. Okay. Regardless of the label, the majority today excises, without a word of explanation, a subset of supposedly non-substantive or unspecific messages from the First Amendment's protection against content-based regulations. This understanding of content-based restrictions contravenes Reed, which held that a law is content-based if it targets speech based on communicative content, not specific or substantive categories of communicative conduct. Only by jettisoning Reed's common sense definition of what it means to be content-based can the majority assert that off-premise rule is strictly location-based and agnostic as to content, even though the law undeniably depends on both location and communicative content. Okay. Moreover, the majority's suggestions the laws targeting broad categories of communicative content are not content-based. It's hard to square with the sign's categories that Reed invalidated. For instance, we found Gilbert's expansive definition of ideological signs to be content-based even though it broadly covered any sign communicating a message or ideas for non-commercial purposes. Okay. Let me pause and think about that one for a second. Okay. $2 from AD. Enjoying the iambic pentameter. Is it an iambic pentameter? I didn't notice. Nor did we suggest that the outcome in Reed would have been different if the sign categories were defined even more generally. The majority answers is not fashioning a novel specificity test, but instead simply quoting the standard and repeatedly enumerated in Reed. And the majority finds this allegedly specific test in a paragraph near the end of Reed, where we noted the law targeted specific subject matter that is content-based even if it discriminates among viewpoints within that subject matter. And then affirmed Gilbert's sign code singled out specific subject matter for differential treatment. These statements never purported to endorse a specificity test of the sort now suggested by the majority. Reed in context, Reed refers to two instances to specific subject matter nationally addresses law that targets subject matter, however broadly defined, as opposed to some other subject matter. They did not refer only to laws targeting some sufficiently specific category of subject matter. Moreover, the concept of specificity or generality appears nowhere in that part of Reed that sets forth its common sense test for content neutrality. If Reed's content neutrality turned on specificity, we would have to say so explicitly when we're stating the test. Okay. Finally, even crediting the majority's strained reading of Reed, passing references to specific subject matter, the paragraph where they appear made clear is describing only a paradigmic example of content-based discrimination. Thus, that part of Reed never professed to announce a comprehensive rule with respect to all laws targeting speech based on communicative content. Our pre-Reed precedents likewise foreclose a construction of content-based that applies only to some content. We've held many capricious speech regulations to be content-based, including restrictions on advice or assistance derived from scientific, technical, or other specialized knowledge, advertising, promotion, or any activity used to influence sales or market share of prescription drugs, editorializing, publication for philaic, numismatic, educational, historical, or newsworthy purposes, anonymous speech. These speech categories are no more specific or substantive than messages regarding off-premise activities. I mean, they do have a point there, to be fair. We've defined content-based restrictions to include all content-based distinctions because any other rule would be incoherent. After all, off-premise advertising could be considered a subject or topic, as those words are ordinarily used. I've made this point as well. And in any event, there's no principled way to decide whether a category of communicative content is substantive or specific enough for the majority to deem it a topic or subject worthy of heightened protection. Although off-premise advertising is a more general category of speech than some off-premise advertising related to religious events, it's a more specific category than others, advertising generally. The majority offers its own ipsit dicta to explain why off-premises advertising is insufficiently specific to qualify as content based under Reed. That's funny. That's good. That basically means its own circular reasoning. That's nice. Worse still, the majority does not explain how courts should draw the line between sufficiently substantive or specific content-based classification and one that's insufficiently substantive or specific. On this point, Austin suggests there's no need to worry because our cases provide guide points from which one can divine the level of generality renders a speech regulation content-based. To be sure, that is sort of inquiry the majority's opaque test invites. But Reed directs us elsewhere to the text of the law in question and whether the law on its face draws distinctions based on the message the speaker conveys. The majority holding that some rules based on content are not, as it turns out, content-based, nullifies Reed's clear test. Well, whatever you can say about this decision, it definitely makes a bright line test less bright line. So, I mean, there's definitely that. The majority suggests that deeming Austin's sign code content-based would require us to adopt an extreme reinterpretation of Reed. Specifically, the majority faults the Court of Appeals for concluding that Austin's regulations were content-based because to enforce the off-premise rule, a reader must ask, who is the speaker and what is the speaker saying? In the majority's view, Reed cannot stand for such a simplistic read the sign test. The majority's skepticism is misplaced. We have often acknowledged the need to examine the content of a message is a strong indicator that a speech regulation is content-based. I mean, one would think. 1 year before Reed, for example, we stated an abortion clinic buffer zone would be content-based if it required enforcement authorities to examine the content of the message that is conveyed to determine whether a violation occurred. That statement was not an outlier. Ultimately, it's the majority's objection to the Court of Appeals' reliance on a read the sign test is a red herring. Its real objection to Reed rule is that any line that it draws distinctions based on communicative content is content-based. I mean, it's sorely a clearer content-based rule for sure. Yeah. The majority next argues that Austin's sign code is content neutral under our precedent, but none of the cases the majority cites supports its crabbed view of what constitutes a content-based restriction. Okay, so this is a point that I'm interested in, the degree to which the precedent does or does not support the majority's opinion, because I'd like to know if the majority is faithfully applying precedent or not. So Reed does suggest one thing, but in the context of other precedent, maybe Reed is better understood a different way. So I think the soundness of the majority's argument is going to turn quite a bit on its proper reading of the precedent. So let's see if the dissent can convince me the majority is misreading the precedent. So let's give that a go. First, in Heffron versus International Society for Christiana Consciousness, the court upheld as content neutral an ordinance providing the sale or distribution of any merchandise, including printed or written material, could only occur from certain booths at the fairground. Such a statute is facially content neutral under Reed because it does not on its face draw distinctions based on the message the speaker conveys when selling or distributing merchandise subject to the ordinance. True, the court construed the ordinance also to limit fund solicit operations, but that was not, as the majority claims, a prohibition on asking for donations. Rather, anyone was free to ask for donations wherever he liked, because the ordinance did not prevent respondents from wandering through the fairgrounds or directing interested donors or purchasers to their booth. Then, once at the booth, the donor could make a contribution. Okay. Second, in Cantwell versus Connecticut, the court invalidated a licensing scheme for religious and charitable solicitation, while acknowledging in dicta the state could regulate time, place, and manner of solicitation. But here we're not faced with a true time, place, or manner restriction, as even the majority concedes. And in any event, Cantwell did not suggest that a content-based regulation could be sustained as time, place, or manner restriction. Its analysis focused predominantly on plaintiff's free exercise claim, and that case predates our modern content-neutral doctrine by 3 decades. Thus, nothing in the case supports the majority's narrow approach to identifying content-based regulations. Okay, all right. Finally, the majority argues that we've previously understood distinctions between off-premise and on-premise to be content neutral. To be sure, in both Suffolk outdoor advertising and Metro Media, the court suggested that some restrictions on off-premise advertising were constitutional. And later, in Members of City Council versus Los Angeles versus Taxpayers for Vincent, the court described Metro Media as upholding a content-neutral prohibition against the sign of billboards. But the statement in Vincent was dictum, as the majority concedes. Both our summary decision in Suffolk and the plurality decision in Metro Media sanctioned off-premise restrictions only insofar as they applied to commercial speech. That is, the court did not decide and need not decide whether the off-premise speech was content-based, because restrictions on commercial speech are subject to strict airment scrutiny in any event. Well, I suppose you still have to read them to determine whether or not they're about a business, but because once you're in commercial speech, that's signed off, I guess that doesn't really count, which kind of makes sense. The majority also finds that finding Austin's sign code to be content-based would render the majority opinion in Reed irreconcilable with Justice Alito's Reed concurrence. In particular, Justice Alito identified 9 types of sign regulation that he believed would not be content-based, including rules distinguishing between on-premise and off-premise signs, and rules imposing time restrictions on sign advancing a one-time event. The majority evidently believes these 2 types of sign regulations necessary turn on a sign's communicative content, like the off-premise sign restriction here. Okay, that reading of Reed's concurrence makes little sense. First, there's no reason to interpret the concurrence as referring to off-premise or one-time event rules that turn on a sign's communicative content. Doing so would make these 2 rules categorically different from the other 7, none of which would ever turn on content. You're going to have to convince me better about that one. And although off-premise and one-time rules could be drafted in terms of a science community of content, as is true here, they need not be. There might be many formulations of on-off-premise distinction that are content neutral. Would you like to give me one? Just for the hell of it? In ordinary usage, an off-premise sign is one that's not attached to or located in close proximity to a building. Okay, so any building. Any building. Okay, so just signs that are near buildings? That would be content-based. Is that the same thing as on or off-premise? I guess that's what Justice Alito was talking about. Any sign that's near a building, which you don't need to know what the sign says, you just need to break out a tape ruler. So, okay. Explaining that ordinary use, an off-premise sign is one that's not attached to or located in close proximity. For example, a city could define on-premise sign as any sign within 500 feet of a building. You don't need to know what the sign says. Just break out a tape ruler. Or a sign that's installed by a business licensed to occupy the premises where the sign is located. Okay. I mean, again, you don't need to know what the sign says. As for regulations of a one-time event sign, Austin itself amended the sign code at the behest of its lawyer, specifically making an ordinance content neutral. That's a good thing. Thus interpreting Justice Alito's concurrence as referring to rules, the term on commutative content, as opposed to rules that are content neutral, is unwarranted. Tape measure? Yeah, tape measure. I said tape ruler. Tape measure, yeah. Second, it would be strange to interpret the concurrence as proclaiming all off-premise signs restrictions are content neutral, considering the long-standing dispute over that question. In fact, 20 years before Reed, then Judge Alito opined there was no easy answer for questions whether exemptions for sale signs and signs related to on-sale activities would render a sign code content-based. Ultimately, seems that quite unlikely that Justice Alito's quick recital of some content-neutral rules purported to preemptively decide an issue that had long perplexed federal and state courts. Near the end of its analysis, the majority invokes allegedly unbroken tradition of on-off-premise distinctions that it claims counsels against faithful application of Reed. To be sure, history and tradition are relevant when identifying and defining those very few limited areas. From 1791 to present, the First Amendment has permitted restrictions upon content of speech. When the majority openly admits that off-premise regulations were not present at the founding, and while it asserts that large outdoor advertisements proliferated in the 1800s, it offers no evidence of any content-based restrictions from that period, let alone off-premise restrictions on non-commercial speech. Ultimately, the majority's only historical support is a regulation like Austin's proliferated following the enactment of the Highway Beautification Act of 1965. Regardless, even this allegedly unbroken tradition did not fall short by a century or two. The majority offers no explanation why historical regulation is relevant to the question of whether off-premise restriction is content-based under Reed and our modern content-neutral jurisprudence. If Austin had met its burden of identifying historical tradition of analogous regulation, as can be done, say, for obscenity or defamation, it would not make the off-premise sign content-neutral. It might simply mean the off-premise sign is a constitutional form of content-based discrimination. But content neutrality under Reed is an empirical question, not historical. Okay. And then it talks a little bit more about Hill. And then it talks a little bit more about the sufficient specificity and problems defining that border. The majority's refusal to acknowledge Hill as simply underscores the division's defunct status. Again, Hill is the only case that could support the majority's ill-conceived contention, yet the majority disclaims reliance on it. Lower courts should take the majority's disclaimer at face value. Hill is a decision we do not cite, and today's decision amounts to little more than an ad hoc exemption. Okay. The content-based distinction drawn by Austin's off-premise speech regulation is by no means clear, and plainly lends itself to suppressing disfavored speech. As the Court of Appeals noted, Austin's prepared counsel struggled to answer whether signs conveying messages like "God loves you," "Vote for Kathy," or "Sally makes quilts here and sells them at 3200 Main Street" would be regulated as off-premise signs. Yeah, they couldn't. That was a problem. They couldn't decide whether those were on-premise or off-premise. And I thought the "God loves you" example was particularly hilarious, because in order to determine whether the sign that says "God loves you" is on-premise or off-premise, we would have to determine where God lives. So, good times. Before us, Austin counsel had similar difficulties, and amici would have proposed dozens of religious and political messages that have been next to impossible to categorize under the rule. These persuasive ambiguities offer enforcement officials ample opportunity to suppress disfavored views, and they underscore Reed's warning that innocent motives do not eliminate the danger of censorship. Well, yeah, I think that those are. I think those are actually both pretty well-reasoned decisions, to be honest. I think they're both pretty well-reasoned decisions. The dissent does have the advantage of being a cleaner and open to less problems, which is attractive. And the majority can't solve the thing. Stephanie says she needs whiskey. Yeah. Stephanie, I don't know if you saw my earlier message, but I wanted to do a stream tonight on the Katie Joy Paulson thing you brought to my attention yesterday. I don't know if you want to do that right away, or if you had thoughts about what time it should be. So let me know what you think. Should we just do another stream basically immediately following this stream, or should we take a break for some period of time? Let me know what you think. But I think both decisions are pretty well reasoned. I think the dissent is cleaner because it presents a bright line rule, right? The majority's decision is more ambiguous, which, is not a first in law. Talk to me afterwards. Cool. Excellent. Yeah, the majority's decision doesn't provide a bright line rule, but that's, not exactly unheard of in law. Because you have to decide when it's enough content-based to be content-based, which is a more ambiguous question. As, even Austin City Council couldn't decide. The fact that they can't decide whether they're on-premise or off-premises, though, might prevent the regulation on intermediate scrutiny grounds, or at least void for vagueness grounds. So I think the Court of Appeals, if they're interested in striking down this decision, still could strike down the decision. It's you can't decide whether these are on-premise, off-premise, no matter how much prep you have. And so it leads to, one of the things government can't do is be arbitrary and capricious. The government cannot be arbitrary and capricious. So if you can't decide after all this prep and all this time, if these are on-premise or off-premise, if you can't decide that, how is some, low-level bureaucrat supposed to do it if you, the, learned attorneys studying this question for months can't figure it out? So I think the sign code might very well not survive on appeal for those reasons. It's it can't survive intermediate scrutiny because it's not sufficiently narrowly tailored, because you don't even know what the hell you're talking about. So I think void for vagueness issues. So I think that's, that's real problems. But I think even though it has as applied challenges, I think the majority's distinction could make sense in theory. It could make sense in theory, even if it's a little bit problematic in its application at the moment. Who's texting me? Potentially criminal, because he wants to talk about something I mentioned. Hold on, let me check this real fast. Okay. Anyways, yeah. So I think the majority's decision could make sense in theory, but as it applied, it might not really work. And I do sympathize with the dissent's view that it leaves open problems that we've struggled with for a long time, and even learned counsel below couldn't figure out the answer to. So, the bright line rule makes more sense. But I don't know. I think the dissent is slightly better, but I don't think it's like overwhelming. I'm a little bit more partial to it because I'm a bit more like of a First Amendment absolutist, I guess, than not. But the majority there's something there that might make sense in theoretical application, but I don't know. Stephanie says, huh? Did I say something that was bizarre? Where I was trying to explain, did I not explain adequately, like the idea that it makes sense is sort of like a theoretical exercise, but actually when you apply it, you run into problems? I mean, who voted which way? It was like the left-leaning part of the court voted with the majority. So it was Sotomayor with Roberts, Breyer, Kagan, and Kavanaugh. Breyer also followed a concurring opinion as addition to being the majority. Alito filed an opinion concurring in judgment. And then Thomas, Gorsuch, and Barrett were in dissent. 99 cents from E. Caroline. Thank you very much for your contribution, as always. So, yeah. All right, so I'm going to sign off for now. I will probably be on with the stream later tonight. I might be on with potentially Criminal on his channel at 9:30 Eastern. Is it Eastern? It is 8:30. So I might be on with him if time allows. So we'll do all that. But I'm going to take a brief break. Call Stephanie, see what she thinks about the stream. If you liked this content, please remember to hit the subscribe button. If the subscribe button is currently red, it is sad. The subscribe button is sad. It does not want to be a red subscribe button. It wants to be a gray subscribe button. Please hit the red subscribe button so it will become gray and be the grayest subscribe button it was always meant to be. That is what it wants in its life, and you can make that happen. Don't forget to hit the join button. For 99 cents, you too can become an uncivilian. Yes, it's true. You see people's name on screen. You want to know how you get your name on screen? It's easy. You just hit the join button or hit the link the bot tells you about from time to time, and you too can become an uncivilian. Also, you get a little cool icon by your name of the scales of justice, and also, I will like you more. And also remember to like the video if you've not done that already. I will be back. Until later, my friends, I hope all is well. Cheers, my friends. And goodbye.